So this is the AO3, that's the evaluation for Unlawful Act Manslaughter, or Udam, Unlawful Dangerous Act Manslaughter. This is what you need for an essay, so you need the 10 AO1 points from my previous video, and then you need the 15 marks for the AO3, which is evaluation and discussion. Just remember to link to whatever the question is asking you, but some of the key points that I thought are worthy of discussion. Number one, there's a discretionary life sentence. This offers the judge greater flexibility when sentencing. So if the defendant is dangerous and needs to be punished, society needs to be protected, for example, the offender can still go to prison for life, but equally if the judge doesn't feel that they are that dangerous or they need to be punished that much, then they could get a suspended sentence and not end up in prison. Some people though, to counter argue this, some people would say that it's not a good thing because you have killed somebody and you're not being punished enough because you could potentially get a short sentence. And remember, you would only serve half of your sentence in prison, which is also another point. The fact that it's common law based, this is the second discussion point. So the definition comes from the case of Larkin. It's been made by judges. If you remember, the only body that should be making law is Parliament. So Parliament have never legislated on unlawful act manslaughter or manslaughter at all. Judges making law is seen as undemocratic. They are unelected. We don't vote for them. And the whole point of a judge, they should be applying the law, they should be interpreting it, they should not be making the law. That should be left to Parliament because Parliament is sovereign. Again, counter argue this. Say, well, hang on a minute, judges are legal experts. If anyone's going to make the law, it should be legal experts. They have more knowledge than individual MPs. They also have flexibility to change the law as society develops. Okay, the third thing that I thought was worthy of discussion is the church test. So the meaning of dangerous, that second element, if you remember, the unlawful act has to be dangerous. The meaning of dangerous comes from the church test. Now, it's an objective test. This means that it comes from the reasonable person's point of view. We don't care if the defendant foresaw the risk of some harm. We are judging the defendant as a reasonable person. So the jury have to try and put themselves in that situation, which I think personally is probably quite difficult to do. It's a little bit unfair because we're not looking at the defendant's state of mind. We're looking at what the jury think a reasonable person would foresee. And it's only the risk of some harm, not serious harm. This is good for the prosecution because it makes it much easier for them to prove, but unfair on the defendant because they're more likely to be convicted. Whilst we're talking about the church test, you can then link this to another key point. The idea of church test says, would a reasonable and sober person foresee the risk of some harm? What is meant by harm? So church said it's physical harm. Stress and fear does not count. And actually that goes against other areas of law that we've looked at. We have looked at GBH, ABH, and bodily includes the mind. But here we are saying fear has to be physical. However, the case of Watson said if it's obvious that the victim is old and frail, then it can be classed as dangerous. So for example, if you go and commit a robbery in an old people's home and somebody has a heart attack and dies, then you can be convicted. The other issue is though, if you committed a robbery in a petrol station and a 15-year-old had a heart attack and died, or like in Carey, she was 15 and she ran away and had a heart attack, they're saying, well, it wouldn't be obvious, that the courts are saying it wouldn't be obvious that a 15-year-old would have a heart condition, so not guilty of Udam. The issue is, this goes against the thin skull rule. If you remember, Blau said you have to take your victim as you find them, and here we're saying, well, actually not in this situation. So there is inconsistency in the law. Another point is the defendant only has to have the mens rea for the unlawful act. So you're going to be guilty of manslaughter even if you never ever considered the possibility of death. death. So if you push somebody and they fall over and hit their head and die, as long as you have the mens rea for the battery, then that is enough. So it can actually be a little bit unfair on the defendant. All they wanted to do was push the person, and then somehow, by some like freak accident, death has resulted and they will be guilty. But I think the law is sending out a clear message that it's not okay to go around committing unlawful acts, i.e. crimes, and it makes it easier for the prosecution. They just have to show actus reus and mens rea of the unlawful act is dangerous and it caused death. The reform proposal, so remember this is just a proposal, nothing's happened. Law Commission, they generally do the proposals for reform. They suggested getting rid of Udam in 1996, and then in 2006 they came up with a proposal called Criminal Act Manslaughter. So the defendant commits a criminal act intended to cause injury, or the defendant was aware it involved a serious risk of causing some injury. Now, I would say that the key thing is it puts it onto the defendant. We are now looking at the defendant's point of view, but Parliament has not changed the law. That means they're probably satisfied with it and they've got better things to do than look at manslaughter. Just a couple of other points. Udam covers a wide range of conduct, which is good, I guess. So battery, arson, ABH, the law saying it's unacceptable to commit crimes. Death could result, so take responsibility for it. If death happens, you will be guilty of manslaughter. There are quite a few elements to prove, which has a nice clear structure for the jury to understand. But if you remember, if one element is not present, then you have to find the person not guilty. The other issue you might want to talk about is the drugs issue. If you prepare drugs but the victim injects themselves, that breaks the chain of causation, and you might want to think, is that right? Is that fair? I mean, maybe the defendant, if they're involved in the drug taking, maybe they should be convicted of manslaughter, because otherwise people who give drugs, you've got cases of ecstasy, people being given ecstasy by their friends or buying drugs and then dying. It's like, should that person be responsible for their death? Did they cause their death? Because giving somebody an ecstasy tablet in itself is not dangerous. It's the taking of it that's dangerous. So plenty of things to talk about if you get an essay on Udam.